This is Edith Cowan. In this whole course, I don't think I'm going to describe to you a more amazing person. She was born in 1861. Her mother died in childbirth while giving birth to a sibling. Then when she was just 16, her father murdered her stepmother and was hanged for his crime. At 19, she came into contact with legal circles when she married the Registrar and Master of the Supreme Court of Western Australia. They had 5 children. While raising those 5 children, Edith Cowan started to become active in voluntary associations for the protection and support of women and children. She was instrumental in the early management of state schools in Western Australia. She helped to establish a house of mercy for unmarried mothers. She was a foundation member of the Children's Protection Society, which was a major player in the establishment of children's law and children's courts in Western Australia. She was then appointed to the bench of the Children's Court in 1915 and was one of the first female justices of the peace in 1920. For most of the decade leading up to 1920, she was also the president of the Western Australian National Council on Women. Now you'd think that was all enough. Indeed, in 1920, she was awarded the Order of the British Empire for her work. But she wasn't done yet. In 1921, Western Australia changed their law to allow women to stand for Parliament. Edith Cowan was first in line and was duly elected, the first woman to sit in a Parliament in Australia. Once in Parliament, she pushed through a bill which opened up the legal profession to women in Western Australia. She continued to serve and advocate right up until her death in 1932. She's remembered today by the Edith Cowan University in Western Australia and by the electoral division of Cowan in the Commonwealth House of Representatives. But you've all actually met Edith Cowan more often than that. Edith's on the back of the $50 note, a worthy memorial to an amazing woman. G'day everyone, I'm Anthony Marinac and welcome to the third of our videos for Module 5 of our Introduction to Law. Today we're going to look at women and the law. And just like the previous video, you might ask, well, why am I talking about women and the law? Well, ultimately I believe that women and the law is not just a women's issue. It's an issue for our whole society, whatever gender we may be. The first thing to consider is what I'm going to refer to as the underlying nature of the law. You see, the law has a set of values. For instance, the law is adversarial. We separate people into sides and then invite them to fight one another, and the judge decides who wins and who loses. From some feminist perspectives, even this is a masculine approach to problem solving. A feminine approach to problem solving, in some views, would be based more on discussion and compromise. We use those processes for alternative dispute resolution, but there's no doubt that at the end of the day, adversarial lawyering rules the roost. Similarly, our laws are often focused on remedies that might be said to be more consistent with a male rather than a female way of thinking. Our criminal law focuses on punishment, although in recent decades rehabilitation and restitution have become more common. Our civil system focuses on damages, the payment of money, and the injuries which can be compensated are physical, or they're expressed in terms of property or money. Injuries to the spirit or to one's state of mind and emotion are often much less compensated. Now, I realise that there's a real danger by saying these things that I'm stereotyping women as being more emotional or emotionally oriented than men. And certainly not all feminists would agree with me at all, and that's okay. But if it's accepted that men and women tend to see the world in different ways, then surely it's clear that our system of law reinforces the way that men see the world and not the way that women see the world. Many of the legal tests we use in the law involve what is called an objective test, where we ask, what would a reasonable person do in this situation? Until quite recently, the The test was actually, what would a reasonable man do in this situation? And because of the doctrine of precedent, when we're thinking about a contemporary reasonable person, we're also taking into account the intellectual legacy of generations and generations, where the consideration was actually the reasonable man. So the reasonable person is still often much more likely to be similar to the reasonable man than to the reasonable woman. There's a lot more to it than just this. Feminist legal writers have spent considerable effort describing the ways in which androcentric or male-oriented values underlie various aspects of the law. My point at this stage is just to say that when considering women and the law, it's not enough to just think about individual issues like, say, sexual assault. There are also underlying values that may tend to make the law less favourable for women than for men. It's important to be alert to that because it's subtle and these things sneak past you. The experience of women in the law echoes the experience of women in so many other areas of our society. For centuries, the law was the preserve of men. In fact, it wasn't until the late 19th century that married women even had a separate legal personality. They were seen by the law as being an extension, almost a possession, of their husbands. The first woman to graduate from a law school in Australia was Ada Evans, who managed the feat in 1902, surprisingly early. However, while she may have had a law degree, she wasn't allowed to actually enter practice. The first lawyer admitted to practice in Australia was Floss Gregg in 1905. As late as 1950, women comprised just 1% of the lawyers in New South Wales. Australia's first female Queen's Counsel, Roma Mitchell QC, was appointed as a silk in 1962. She was also our first female judge in 1965. It wasn't until 1997, when Justice Mary Gaudron took the bench, that we had a woman as a High Court judge. And if you can believe this, it wasn't until 2016 that Justice Susan Kiefel became our first female Chief Justice of Australia. Nowadays, you'll find that in some jurisdictions there are more female lawyers than men, and it's absolutely common to find more women than men in law schools. Women in Australia formed organisations like Australian Women Lawyers to represent their collective interests. None of this is yet translated into having equal numbers of women at the bar, or on the bench, or in partner roles in major firms, but that tide seems inevitable. It's just a pity it's taken so long. I want to talk about key issues for women in the law, but that sounds like a silly way to say it. Because there are women in the law doing everything from assessing bombing targets for the Air Force to make sure they're within the rules of war, to arguing patent applications, to trying criminal cases. It's not as though women lawyers are somehow confined to women's legal issues. However, there are some issues which characteristically affect women, whether they be women in the profession or women in the community, differently. It seems appropriate in a discussion of women and the law to look in the direction of those issues. Before doing so, I need to say that all of these are complex areas that I will be discussing quickly. If they interest you, find out more, because these short summaries are only intended to tell you what the issues are, not to give you anything like a deep explanation. The first issue I'd like to touch on is what I've described as the protection of sexual and personal integrity. This is an area which will overlap with some of the other areas I'm going to discuss, and it's also a huge area on its own. But there are some themes. The first of those is around rape and sexual assault. Now, whilst it's true that men are raped in Australia, it would be senseless to pretend that this is not a gendered issue. Women are raped far more often than men, and it's generally understood that the disparity in the statistics would be even greater if all of the crimes were reported. It's generally accepted that somewhere in the order of 85% of rapes in Australia are never reported to police. From a lawyer's perspective, this is a huge problem. I mean, surely one of the basic functions of our criminal law, one of the basic functions of law altogether, is to protect people from enduring harm at the hands of others. How did we reach the point where the law offers so little protection? What can be done to change this? Well, many of the answers to this question lie in the fields of sociology, criminology and policing, and we're not really going to touch on those. However, from a legal perspective, it long ago became clear that there were some structural concerns in our legal system. The first arises from one of our most cherished legal notions, that a person is entitled to the presumption of innocence and that a crime must be proven beyond reasonable doubt. It's sometimes very easy to be pious and to say it's better to let 10 guilty people go free than to convict one innocent person. But that's going to be little consolation to the person who's been raped by one of the 10 guilty people who go free. A perception, a justified perception, that perpetrators of rape were able to simply get away with their crimes became a key reason for victims not to report those crimes. A second issue arises from the adversarial nature of our criminal justice system. It's fundamental that an accused person must have the right to cross-examine the witnesses against him or her. However, in a rape trial, this means a victim forced to relive the nightmare of the offending, often forced to reveal intimate details of her own behaviour in a public forum, in circumstances of humiliation and trauma. Again, little wonder that victims were reluctant to come forward. And yet we can't just abandon the presumption of innocence. We can't just abandon the criminal standard of proof. And in our common law system, we're not about to abandon adversarial justice. So what could be done? Well, a few reforms have been set in place, primarily as a result of the work of women advocates in public debate. First, rape trials are often held, or parts of them are held, in closed court, and there are serious restrictions around what details can be reported in the media. Names are suppressed in order to reduce the public exposure of the victim, which in turn reduces the public humiliation aspect of the trial. Second, the victims of rape or sexual assault are given the status of vulnerable or protected witnesses. This means that they will give their evidence from behind a screen or from a separate room by video link. This means they won't have to be in the same room and within the view of the person who committed the offences upon them. Third, as we've mentioned in a previous video, there are now what are called rape shield laws, which prevent defence counsel from asking certain types of questions which had previously been commonplace, and which focused on the sexual history of the victim, essentially in an effort to project her as a promiscuous person who was likely to have in fact consented to the sexual activity. In addition to these changes, there has been an extraordinary amount of work done, mostly within feminist jurisprudence, about the nature of consent. Sometimes it's said that no means no and yes means yes. Modern sexual relations, though, are very rarely that simple. Does yes mean yes if the person saying yes has been threatened? Does yes mean yes if the person saying yes has been manipulated emotionally? Does yes mean yes if the person saying yes is seriously intoxicated? If there isn't a yes but there isn't a no, does that equal consent? What if a person is sleeping? What if a person consents to one type of sex but then the other person engages in an entirely different type of sexual behaviour? Discussions around these sorts of more complex questions have resulted in actual changes to the law. It's now quite clear, for instance, that a heavily intoxicated person can't give consent. It's clear that if a person spikes someone else's drink, including with extra alcohol, then any consent after that won't count. It's clear that consent can be withdrawn at any time. It's clear that consent has to be free and enthusiastic and willing. All of these changes make it easier for a prosecutor to show the absence of consent and therefore to obtain a conviction. The second issue I want to talk about is discrimination and harassment. Now, I don't feel old, but it's certainly within my personal memory to remember a time when it was commonly understood that there was men's work and women's work, men's sports and women's sports. I can remember a time when there were still earnest debates in Australia about whether the concept of mateship could extend to a woman, or whether it was reasonable to expect a man to shake a woman's hand. As recently as 2010, I personally umpired an Australian football game with an excellent female umpire, and we very nearly stopped the game due to the abuse she received from the North Wagga Football Club because they thought women shouldn't be footy umpires. I can certainly remember a time when if a man pinched a woman on the backside, she would be considered a bad sport if she objected. None of this is ancient history. And even though a lot of it is more subtle, many of you who are women watching this video are already shouting at me through the screen that you still endure this sort of nonsense every day of the week. Well, I wish it didn't happen, but at the very least we can say it's illegal. And the story of how it became illegal really begins with the United Nations Convention on the Elimination of All Forms of Discrimination Against Women. This convention was passed in 1979 and Australia signed it in 1983. The following year, 1984, saw the passage of the Sex Discrimination Act 1984, which outlawed discrimination against women, with very limited exceptions in work, education, commerce, private associations, ownership, and the law. The Sex Discrimination Act also outlawed various types of sexual harassment and created the Sex Discrimination Commissioner, who now works within the Australian Human Rights Commission with a function of advising government as well as adjudicating disputes. Now, much remains to be done. For instance, it is still the case that issues like paid maternity leave and access to reasonable childcare arrangements inhibit women in employment. However, the Sex Discrimination Act really was a watershed which drove major social changes in Australia right down to the behaviour of everyday Australians. If you don't believe me, jump online and start looking at random clips from old shows like the Paul Hogan show from the 1970s and look at the sort of treatment of women which was regarded as being somewhere between normal and amusing then, but which would be considered absolutely appalling now. I was going to insert one into this video, but when I went looking, I suddenly realised there was just no way I could do it. The university would never allow it, and neither would my personal ethics. Again, though, the work is ongoing, and the law which we all practice will be continuously reformed, one suspects, to deal with issues of discrimination and harassment. Now let's talk about domestic and family violence. As with sexual assault, it should be clear that there are male victims, but it makes no sense at all to pretend that this is not a gendered issue. Paradigmatically, domestic and family violence is perpetrated by men against women. And while the term violence is used, what we're really talking about is control. This can mean belittling and manipulative behaviour, isolating the victim, controlling finances and life decisions. It can mean physical harm or threats of harm. And far too often, it may even result in the death of the victim. Domestic and family violence has quite a shameful history in the law. In this introduction to law course, we've already referred several times to the fact that women were essentially the property of their husbands under the conceptions of law we had for many years. From a legal perspective, marriages were considered to be sacrosanct and the law was reluctant to look within them. Cruelty was for a long time a basis for divorce, but the bar was set very high. For instance, it was perfectly allowable for a man to use reasonable force to physically chastise or discipline their wife. For many years there was what was known as the spousal immunity, which meant that a man could demand sex from his wife or simply just rape her. without any legal consequences, because by marrying him, she had, in the eyes of the law, consented to his having sex with her wherever and whenever he wished. Wives were not compellable against their husbands in criminal trials, and there was no domestic violence legislation anyway. If police were called to a domestic scene, then unless there was a serious crime, it was treated as a social issue and not as a criminal issue. The first battered wives refuge, that was the term used, wasn't opened in Australia until the 1960s. Through the 1970s and 1980s, there began to be changes in public attitude, away from the view that what happened in marriages should stay in those marriages. And it started to become clear that generations of women had suffered unspeakable abuse, and the law had done nothing to protect them. In Queensland, the first legislation directly dealing with domestic violence wasn't established until 1989. But there was still a long way to go. In 1993, a judge in South Australia, Justice Boland, said, quote, "There is, of course, nothing wrong with a husband, faced with his wife's initial refusal to engage in intercourse, in attempting, in an acceptable way, to persuade her to change her mind, and that may involve a measure of rougher than usual handling." End quote. In 1994, Alexander Downer, who was then leader of the opposition, who later became foreign minister and who is currently in 2018 Australia's ambassador to the United Kingdom, was talking about his party's slogan, "The Things That Matter." He joked that their domestic violence policy should be called "The Things That Batter." In 2012, Queensland updated its domestic and family violence laws, but the problem remained and remains. In 2015, Quentin Bryce, a lawyer, Governor of Queensland, Governor-General of Australia, handed down the Not Now, Not Ever report, which made recommendations to protect women from violence. In Australian jurisdictions, it is possible for victims of domestic violence or police on their behalf to seek protection orders. The value of those protection orders is heavily contested. Too often, breaches of those orders seem to result in little consequence, and despite the best efforts of the court, they are usually a very blunt instrument for trying to deal with the complicated and nuanced circumstances of a woman in crisis who wants to make her own decisions about her future, but who wants to make those decisions in safety. The issue of domestic and family violence is an ongoing epidemic. This particular battle is far from won. Another issue affecting women in the Australian law is the whole area of family law. Now, I'm going to be very careful here because this issue really is much wider than just women. It is clear that many men find themselves in various degrees of absolute crisis in the family law process. Certainly there are many men's groups who earnestly and in good faith believe that men don't get a fair go in family law. It is absolutely clear that often the children of separating families bear the greatest burden of suffering. So why do I mention family law as an issue for women in the law? Well, for one thing, the passage of the Family Law Act 1975 was a great leap forward for women because it instituted what is called no-fault divorce. Before the Family Law Act, it was necessary for parties to sue for divorce by arguing that the other party had acted in a way that amounted to desertion or cruelty or adultery. So one party would have to be held at fault for the divorce. And that would have implications for things like who got the kids and how marital property was separated. Well, the Family Law Act did away with all that nonsense. Parties can now separate without needing to bring evidence of desertion, cruelty or adultery. And parties are now able to negotiate property settlements and parenting plans together. The court becomes a last resort when parties have been utterly unable to sort things out for themselves. Since 2008, women in de facto relationships have stood in the same position as women in married relationships when it comes to both children and property. The effect of all this, and the reason I list it as a women's issue, is that it has provided a reasonable and dignified way for women to leave marriages, whereas in previous generations they may have been trapped in those marriages permanently. In terms of enhancing women's self-determination, this revolution in family law was crucial. Family law, however, remains a heavily and bitterly contested area of law. Who amongst us does not know a separated couple who've spent ridiculous amounts of money and ridiculous amounts of heartache trying to achieve or enforce outcomes through the family law? Like most of the other issues I have mentioned for women, this one is far from over. Finally, I'd like to talk about women in prison. From the 1980s TV series Prisoner to more contemporary shows like Wentworth and Orange is the New Black, we have a certain social history of romanticising the idea of women in prison. The reality is more complicated and more tragic. Australia's greatest advocate for women in prison has long been Debbie Kilroy, a lawyer and former prisoner who founded and still leads the organisation Sisters Inside, which advocates on behalf of women prisoners. In a relatively recent speech, she noted that statistics are sometimes unhelpful because the lives of women prisoners are complicated, but those figures sometimes do tell a story. What figures? 73% of women prisoners have previously been admitted to psychiatric units. Nearly 40% of women prisoners have previously attempted suicide. Over 1/3 are Indigenous. More than 85% experienced childhood abuse. 98% experienced physical abuse as an adult. Over 70% have a substance abuse addiction. And perhaps most tragic of all, 85% are the primary carers of children at the time of their sentencing. What does all of this tell us? For one thing, it tells us that many of these women are not in prison because they're criminal. It tells us that in many cases, their offending was almost the inevitable result of their circumstances. And it tells us that these women don't need incarceration, they need treatment. It tells us that when women are sent to prison, there are almost always children on the outside who lose their primary carer. Many of these children will end up in the fostering system, sometimes for years. On exit from prison, many of these women have the same problems they had before they went to prison, and on top of that, the economic, employment and social disadvantages that comes from having been in prison. And the personal tragedy of either the loss of their children or the inevitable loss of rapport and connection to their children as their children bond with others. Now, some of these arguments can be made for male prisoners too, and indeed there are sound arguments to reserve prison for only the absolute worst of offenders. But one does have to wonder how, by taking women who have mental health disorders and lead powerless lives and putting them in prison with its mental health challenges and utter powerlessness, how we expect to somehow have a better and more capable woman, a better and more capable mother, walk back out the gate into society. A lot of what I've talked about today is well and truly beyond my personal experience. I don't see the world as a woman. I haven't faced the challenges and disadvantages, the discrimination and harassment, the violence and threats of violence that so many women in our society face. But as lawyers, all of us, regardless of our gender, should understand that while the idea of equality before the law is a beautiful concept, in many cases it's actually a beautiful fiction. The challenge for us as a profession is to ask, what can we do to change this?